that's continuing with my research. That is my papers. The third chapter which I put up was the history of laws on domestic violence in India. We had previously a law against dowry and crimes, so that's very very important. After independence 1947 and in 1950, that is, it made a constitution and that is still in place today. So part 3 of the constitution protects the fundamental rights such as the right to life, which has been interpreted to mean the right to live life with dignity. Yes, so over here we see that without violence, that is Article 15 of the Constitution, gives the state the power to take positive steps to protect women. Article 15 has been used many times by the Indian Parliament to pass special laws or executive orders to protect women. These laws and orders have usually been upheld by the courts. India became independent in 1947, but it took 14 years for the country to pass its first law about violence against women. That's the Dowry Prohibition Act. Yes. We see that DPA was passed in 1961. So it made illegal to give or receive dowry, but the act did not stop the practice of dowry very well. In 1984 and 1986, the Indian Parliament passed the Dowry Prohibition Act, Amendment Act, but they did not do much more than the 1967 Act. 61 Act. In 1983, the criminal law, the Second Amendment, was passed, which added Section 498A of the Indian Penal Code. This was the result of a campaign to stop domestic violence caused by, dowry. Now, under the rule, any husband or member of his family who treats the wife with cruelty could be fined, and here also, the cruelty could be fined and sent to prison for up to 3 years. This is a serious crime that can't be forgiven. Cruelty is defined as any intentional action that is likely to drive the woman to commit suicide or to cause grave injury or danger to the life, limb, or health, whether mental or physical, or harassment that involves, we say, coercing the woman or any person related to her to meet any unlawful demand. See here, it is unlawful demand for any property or valuable security, or is on account of her or any person related to her failing to meet such demand. But as we will talk about it in part 2, many cases brought under this law have failed because law enforcement officials didn't do their job over. Yes, in India it is a bit possible corruption. So that this section was that says that a woman's husband and in-laws are actually criminally responsible. So in 1986, section 304B was added to the Indian Penal Code. 304B was added to the Indian Penal Code. This made dowry death a new crime. Yes, friends. So here in my third chapter, I have introduced this Prohibition of Dowry Act because we lawyers face many cases. Even recently, I am just handling a case of a woman just 7 months married, but she was often taunted by her even mother of that house that her parents have not brought anything. So this also becomes an emotional brain drain for that girl who's actually working, but she cannot concentrate in one of the corporates where she's working. So still it's predominant, though she is working woman and she can contribute to the salary of the home of the spouse, but it is not stopped. So we women lawyers are finding it very difficult because all this money or whatever articles that the in-laws claim are as shown as gifts to the groom and his relatives. So it's not being handled very nicely by the law enforcement agencies. These rules also didn't give Indian women civil remedies like injunction, protective order, interim relief, and other kinds of help like shelter and money. Also, neither of these laws makes people criminally responsible for physical and mental abuse that has nothing to do with dowry demand. In the case of Wagmare versus State of Maharashtra, for example, a woman was severely hurt emotionally and physically by her husband and his family, and she ended up killing herself. So they bet her up and bothered her a lot because she wanted a motorcycle. Most shocking of all, after she had married for only 2 months, a brother-in-law poured kerosene on her. So this was the case where it was there was no proof that the bike was sort of demanded for dowry. So these included. So therefore, the Violence Act was signed into law after more than a decade of talks and lobbying. So we see that in all this above scenario, Vishaka versus State of Rajasthan happened. That is, second one is the Protection of Women from Domestic Violence was passed, and after that we also saw this in my chapter where we have described what is violence. Section 21 of the PWD we saw. Then PWDWA doesn't make any new crimes. So it was a respondent. What does a respondent mean? It was actually a man of the home who treated violence. But now we are having the mention over there, that is any female relative. So negative consequences of the protection of women against one, discrimination of male partners and their female relation. It's created in response to the ineffectiveness and misuse of existing legislation aimed at preventing violence against women. So these are the ways where the government of India took, of course, a lot of cases. For example, in Aruna Pramod Shah versus Union of India, the constitutional legitimacy of the PWDVA was challenged in the Delhi High Court in the grounds that it is unconstitutionally gender specific. The court, on the other hand, upheld the act, saying the contention that the act is ultra vires the Indian constitution because it provides protection only to women and not to men is totally devoid of any merit. We do not rule out the prospect of a man becoming a victim of domestic violence, but such incidents would be rare, necessitating or justifying parliamentary protection. According to PWDA, a respondent is any male adult who has or is in a domestic relationship with the aggrieved person. The court determined that PWDVA gender-specific nature was a fair classification in light of the Act's intent and purpose, and that it was thus constitutional. Like treatment to both does not in any way detract from the sanctity of marriage, the court added, since an assumption can legitimately be drawn that a live-in relationship is typically begun and continued by the male. So, Section 18 of the PWD allows a magistrate to impose prohibitory orders if they have reasonable grounds to believe domestic violence has occurred or is likely to occur. So, it's worth noting that a court can issue an injunction barring the male offender from attending any area frequented by the aggrieved person. So yes, not only the marital home, but also wherever she works or maybe wherever she is, the court can object that particular person's entry. So places frequented by the aggrieved person obviously include the home where both parties live prior to the alleged domestic violence. The residence in questions may be owned or rented by the male respondent with the right title or interest in it for the injured lady. Under this section, the magistrate may restrict the male respondent of access to his own home and bank account. In addition, Section 23 authorizes the magistrate to issue the interim. Very important over here. It authorizes the magistrate to issue interim orders during any proceedings before them, including those involving a Section 18 order. He may grant an ex parte protection under Section 18 if is satisfied on the basis of the affidavit inter alia that the application indicates that there is a likelihood of domestic violence being perpetrated. So, yes, the protection order issued under Section 18 remains in effect until the aggrieved person requests for discharge. According to Section 25, yes, thus, if a woman alleges misconduct by a male respondent with whom she has shared a home and files an application under Section 18 of the PWDA, read in conjunction with Section 23, asserting an affidavit that the latter is likely to subject her to emotional abuse. Very important, the magistrate can issue an ex parte interim protection order prohibiting the respondent from entering into his own home or operating his own bank account. Yes, recently I handled the case of an eye surgeon where yes, the interim order of protection was issued and he was barred entry to his own marital home. So there are, though the case filed is restitution of conjugal rights, he has filed an application for restitution of conjugal rights, but the interim order states when she complained of violence, domestic violence, the magistrate has passed an interim order that he is restrained from entering the marital home. So yes, next is the police harassment. Domestic violence victims in India have long been denied justice due to the police failings to inadequately investigate domestic violence and follow legal decisions. Local police units are rife with, yes, the issue problem of India. So it is like, the rich manage, the politically affluence manage, and the police are frequently hesitant to file charges against or investigate powerful people. Yes, we have seen this. In one of my case, we have seen the accused was a diamond merchant. It took 4 years for me to save that woman who was not only facing violence at home but also sexual harassment by her own father-in-law. So it was a sad case which ended up in judicial mediation. And yes, now the girl is settled happily. Second time, the legitimate children born out of the father-in-law was handed over to the court, and the court handed it over to the father-in-law because the DNA report had proved that the kids were illegitimate and belonged to the father-in-law. So these are cases where the powerful takes the help of the authorities and see to it that the case delays, the case prolongs, and in the end the victim is forced to withdraw all the complaints. So it's like justice delayed. Again, justice delayed is justice denied. So the pervasive belief that domestic violence is a family problem that should be dealt privately explains the hesitations to investigate and report cases of domestic violence. As a result, many victims believe that if they disclose their accusation to the police, they would be dismissed. Domestic violence claims are almost definitely underreported as a result of the fear. As a result, police investigations into dowry-related offences and domestic violence have generally been inadequate. The PWDA has a number of provisions geared at resolving these issues, particularly with regard to public action in domestic violence. This act also requires police officers to participate in sensitization and awareness training. Furthermore, several police departments have added female officers to their team in order to encourage more victims to report to domestic violence. Yes, despite this revisions, police corruptions continue to be a major hindrance for the PWD. I'm very sorry, but yes, in some cases, we cannot say in general, but it happens, and we see the women have to again approach the National Commission of Women if there isn't any help from the police. So misuse of other legislative provisions, Section 498A of the India. So Section 498A, the most prevalent provision invoked by the women who have been victims of domestic violence is 498A of the Indian Penal Code. A female petitioner has the right to make a complaint under this section as well as the PWDVA application. This PWDVA and Section 498 both apply comparable harm and harassment test. Grave injury to a woman's health is likewise clearly recognized as cruelty offense under Section 498A. The constitutional legitimacy of Section 498A has been questioned in a number of cases, due to its proclivity for abuse. The husband of a lady who had filed a complaint against him under 498A challenged its constitutional legality in Sushil Kumar Sharma versus Union of India. Yes, here that it is widely misused. The claim was denied by the Supreme Court, which held that the mere possibility of misuse did not make a provision unlawful. The court's closing comments, however, summed up the possible problem with the provisions. The provision's goal as to keep dowry menace than from big happening. However, as the petitioner correctly points out, there has been several occasions where complaints have been made with an ulterior motive. The ulterior motive, of course, is, women start claiming alimony, huge alimony, once they agree to withdraw. So there are a lot of cases where they are forced to, the family of the respondent is forced to pay huge alimony just to withdraw the criminal cases. Many of our cases we have seen this happening. In such circumstances, the accused acquittal does not always erase the ignominy that is suffered during and prior to the trial. The fact that the clause is constitutional and intra vires. Ultra vires means beyond the power, intra vires means within the power of the Constitution. So yes, it is within the power of the Constitution, and the right to wreak personal vendetta or harass others. As a result, the legislature may need to figure out how to deal with people who file bogus complaints or false complaints or claims. Until then, the courts must deal with the matter within the current system. What's happening? Yes, until then, the courts must. Yeah, as previously stated, the goal is to attack the source of the dowry threat. However, if the opinion is abused, if the option is abused, a new form of legal terrorism could emerge. The provision is meant to be used as a shield rather than a weapon by the assassins. If the cry of wolf is made too frequently as a joke, help and protection may be unavailable when the real wolf appears. In other words, the court acknowledged the possibility that this provision could be abused, but decided that it was constitutional because the petitioner had not shown that such abuse had occurred. In the Raj versus Sunita, the Delhi High Court considered a challenge to Section 498A constitutional validity on the basis that it violated Article 14 of the Indian Constitution as a guarantee to equality. According to the petition, 498A gives police discretionary powers and concept of cruelty is unconstitutionally ambiguous. This provision was maintained by the court, which stated that the term cruelty is adequately defined in the statute and that interpretation would not be arbitrary. Very important over here. The interpretation of law will not be arbitrary. Then most of the laws would have to be declared unconstitutional. The court highlighted that it had the authority to sentence an offender to up to 10 years in prison for the same offense, which could lead to some arbitrariness. Sometimes, nonetheless, it came to the conclusion that Indian law clearly shows that such discretion is not arbitrary and hence does not violate Article 14 of the Constitution. The High Court of Punjab and Haryana concluded in Krishan Lal versus Union of India that Article 14 of the Constitution mandates that all persons similarly situated be treated equal. So therefore, the government, on the other hand, may make distinctions between people based on justifiable classifications. In light of this, the court determined that classifying a husband and his relatives for the purpose of imposing criminal punishment is justified, particularly when the alleged violence occurs within the marital home, where gathering proof is difficult. As a result, it determines that Section 498A did not violate Indian Constitution's Article 14. So misuse of Section 498 section appears to be then utilized by the police despite its constitutionality being upheld. The general public in India believe that this provision is primarily used to bring false charges in order to harass or blackmail an innocent husband and relatives. In Verulu versus the state, the court sought an end to the harmful trend of false complaints that had been causing the husband and his family excessive suffering. Another court in Sapneshwar Devuri versus State of Orissa remarked that the murdering of daughters-in-law for non-fulfillment of demands has undoubtedly become widespread, but that even when a young bride dies of natural cause, suspicion is instantly put on the in-laws. Yes, it is put on the in-laws. According to opponents, Section 498 of the IPC is badly written and inadequately drafted provision that allows a woman to bring false petitions that result in the detention of innocent males and relatives without investigation. Male activists argue that the societal consequence of such prosecutions have resulted in the suicides of married men who have been charged. They further argue that married women frequently utilize this provision to bully their husbands and in-laws into agreeing to their request when the divorce is imminent. As a result, marital strife is masked as domestic violence or cruelty. So, if the stories of fraudulent claims are true, it would be violation of due process of law, because this clause was meant to be to shield against violence, not a sword or a negotiating tool. So, it should not be treated as a negotiating tool. Now, yes, publications like Manushi, Gender Studies magazine, have also highlighted the misuse of such laws while praising the effectiveness. In some circumstances, female complainants frequently assert threats of dowry, demands in charges of domestic violence or cruelty. According to Manushi, even when dowry is not involved, lawyers and cops are said to have pushed complainants to create false charges in order to bring the male partner's family members into the case. Madhu Kishwar, a well-known campaigner for women's rights, has also mentioned incidences of bogus dowry allegations that have been widely publicized. Unscrupulous families may also use 498 and 406 of the IPC to fabricate or exaggerate claims in order to demand the return of more than was provided as Sridhan. Similarly, a woman is pushed to exaggerate their acquisition of domestic violence in order to obtain a higher settlement as a condition of mutual consent divorce. So, as a result, a high proportion of Section 498A cases are later withdrawn. So, yes, I told you, in most of our cases this happens. Claims, false claims, and then finally they come to a mutual consent in the process, in the legal process that happens. But then this is actually unfair. So Manushi also discovered several examples on which attorneys, instructed their male clients to file a divorce petition before the wives file a Section 498 complaint against them. Yes, so before she files a 498A, lawyers often advise the men to file a divorce petition. So these men can be therefore properly argue that the accusations of cruelty was simply made in revenge for the husband's divorce filing. So police would frequently utilize the fear of arrest under Section 498 to extract enormous quantities of money from her husband's family, according to Manushree research. So many have also claimed that the police threatened to reject or delay the granting of bail to accused individuals and their families unless hefty payments are presented to others. So these are the research by women organizations like Manushi. This assures that the lawyers collect hefty settlements from their male clients as long as they were entitled to a portion of the amount as a commission for coercing the husband's family in a domestic abuse situation. Neither the wife nor the husband benefit from Section 498 according to Malimat Committee report on the criminal justice system. Very important, the Malimat Committee report on the criminal justice system, because cruelty is non-bailable and non-compoundable charge. Innocent people are routinely detained and imprisoned, resulting in shame and mental and physical hardship. Now, according to the report, These makes reconciliation or a return to the marital home nearly hard. For example, even if the petitioner has to make apologies by dropping the complaint, she will be unable to do so because the infraction is not reversible, that is non-compoundable. As a result, husbands accused of cruelty against their wives are unlikely to reclaim their family. The Malimat Committee statements stands on reconciliation and compromise. On the other hand, raises several doubts. Yes, almost all women who seek help from the government or non-governmental organization for domestic violence cases will almost likely return to violent domestic settings. Both the government and the non-governmental organizations NGO advocate for a mediation procedure between the husband and wife to address marital differences in which the woman negotiates from a disadvantage due to patriarchal cultural norms. As a result, in many circumstances, the woman may feel presumed to drop the case. Yeah, presumed to drop the case. So, her criminal complaint against a violent husband in exchange for a settlement or a quick divorce. So in 2011, the Rajya Sabha Upper House of Parliament Committee on Petitions accepted a petition claiming misuse of Section 498A in light of Malimat Committee report. Many women rights organizations were outraged, claiming that any misuse was the product of faulty police investigation. It was the result of faulty police investigation, and arguing that any misuse was the product of faulty police investigation, and arguing that any revision to the law would be aggressive steps in Indian women rights law. They also claimed that the notion of a big group of women fabricating stories of assault and harassment was not just instant but was implausible. According to data from the National Crime Bureau, the number of dowry fatalities climbed from 1975 from 6,975 in 1998 to 8,093 in 2007. So when we see analyzation of historical domestic violence decision in courts around the world, I have also mentioned about around the world courts, what are the decisions being taken. So, what is decisive is whether a violation of rights recognized by the American Convention on Human Rights occurred with the support or acquisitions of the government, or whether the state has allowed the act to occur without measures to prevent it, to punish those responsible. This was in one of the English court which happened. Yes. It was European Court of Human Rights or the Inter-American Commission on Human Rights have been included. So each decision appears to have either established a legal precedent or exemplified the execution of progressive domestic violence legislation. The Inter-American Court of Human Rights specifically condemned on state tolerance of human rights violations in Velasquez Rodriguez versus Honduras, emphasizing the above statement. So, yes, domestic and familial violence against women is defined as an action or omission based on gender that causes the woman's death, harm, bodily, sexually, psychological pain, moral or patrimonial damage. So, according to the Brazilian Maria de Pena law, because of the unjustified delay and irresponsible processing of this violence case, the Commission ruled that Brazilian law enforcement personnel had infringed the petitioner's right to a fair trial and legal protection. In its ruling, the Commission suggested that the victims receive quick compensation and that the national measures be adopted to end the judicial system's tolerance of domestic violence. The Inter-American Commission on Human Rights highlighted the need to evaluate and update current laws and policies to remove discrimination against women in the case of Maria Mamarita Mestanza Chavez versus Peru, which involved forced sterilization. I told you These is also coming under the domestic violence, forced sterilization against the wish of a woman, family planning measures being taken. So the European Court of Human Rights, ECHR, is responsible for a number of groundbreaking domestic violence regulations. One of the first decisions in the case of Array versus Ireland was issued in 1979 and dealt with nations' obligations to uphold the Convention for the Protection of Human Rights and Fundamental Freedom. Here, the petitioner in the case sought to end her marriage due to her husband's claimed physical and mental mistreatment towards her and their children. She was unable to find a lawyer prepared to act on her behalf due to the prohibitivity high cost of obtaining a judicial separation order. The heart of Aries' complaint is not the state has acted, but that it has failed to act, not having been placed in a situation where she could appeal to the High Court. She was unable to seek acknowledgement in law of her of her de facto separation from her husband. The ECHR concluded. So as a result, the court determined that Ireland had infringed Aries' rights by failing to provide her with a method of accessing the country's legal system. Yes, infringing on her right to access courts and respect her family life. So domestic violence is an obvious breach of multiple European conventions on human rights. Nonetheless, the European Court of Human Rights did not deal substantially with the case concerning this subject until 2007. After years of domestic violence, the appellant moved her divorce and custody in Bevacua and SV Bulgaria. But Bulgarian officials took an unusually long time to handle the case. The appellant and her son lived in constant fear of harassment by the husband throughout the proceedings as a result of this bureaucratic incompetence. Yes, the European Court of Human Rights held that Bulgaria had violated its responsibilities and Article 8 of the Convention for Protection of Human Rights and Fundamental Freedom by the requiring the domestic violence victim to pursue the case under the unique circumstances of the case. The applicants were awarded cost and damages by the court. The case is notable since it is the European Court of Human Rights' first decision on domestic violence. The European Court of Human Rights emphasized the necessity of monitoring how laws were implemented in M.C, that is MC versus Bulgaria. Now, although the clause outlawing rape in Bulgaria's penal code did not mention physical resistance by the victim, the case determined the physical resistance appeared to be required in practice to pursue a prosecution of rape. Now, when we see over here, the domestic violence can be a violation of the right to life, Article 2, the right to be free from torture or inhuman or degrading treatment, Article 3, the right to respect for private and family life, Article 8, and prohibition of discrimination according to a series of cases decided by the European Court, Article 14. The case of Opoza versus Turkey is an example of this jurisprudence. It was a case in which the applicant claimed that the authorities failed to protect her and her mother from her husband. Now, domestic violence, which culminated in the mother's death and her own mistreatment, the court found that the authorities failed to protect the applicant's mother's right to life, resulting in violation of Article 2. The applicant had been threatened with violence, injury, and death, and she claimed that the authorities had been incompetent in their handling of a case, causing her agony and dread in breach of Article 3 of the Convention. She claimed that the injury she had sustained constituted torture under Article 5. Yes, The court determined that the violence was severe enough to qualify its ill treatment under Article 4, Article 5, but it did not say whether it was torture rather than inhuman or humiliating treatment. The court came to the conclusion that Article 3 had been violated. It read, as a result of the state's inability to adopt the preventive measures in the force of effective deterrence against the applicant's husband's serious violation of a personal integrity. Now, furthermore, the applicant argued that there had been a violation of Article 14 of the Convention, which the court agreed with domestic violence primarily affects women, according to the petitioner, who also argued that judicial inactivity in Turkey produced an environment conducive to domestic violence. The ruling is a wake-up message to European governments to treat domestic violence very seriously. Therefore, the European Court of Human Rights acknowledged for the first time in Opus versus Turkey that domestic violence is a form of discrimination against women and the nations must eradicate and remedy it. Domestic abuse is not a private family matter according to the ruling, and governmental protection from it is in public interest. Domestic violence, ongoing nature, and the harm it causes to women's integrity were highlighted in the case. The verdict had the effect of reducing the effects of normalization and the impact of repeated infractions on women who are subjected to men. The link between discrimination and violence was established in this case, where the European Court of Human Rights ruled that the state's inability to protect women from domestic violence constituted a violation of their right to equal protection under law. The Bivacque and Opus opinion constitute a significant step forward in the development of the due diligence requirement. Very important, the due diligence requirement. Yes. Convention must provide individuals with the tools to that is to acquire an enforceable protective measure, which as an order of protection, a restraining order, an expulsion order, as the court concluded in this decision. Domestic abuse must also be prosecuted criminally where it is in public interest, even if the victim withdraw her complaint, even if the victim withdraws a complaint. So yes, these fundamental norms have received binding legal authority within the jurisdiction of the ESHR thanks to the holdings in Bivacque and Opus. The European Court of Human Rights deserves praise for its jurisprudence in this field, which is having a significant international impact, as the recent Jessica Lenahan case demonstrates. In its ruling in Jessica Lenahan Gonzalez, that is versus United States, the Inter-American Commission on Human Rights referred significantly to the European Court's jurisprudence. This is the first case taken before an international human rights court by a domestic abuse survivor against the United States. Very interesting. The case involves Ms. Lenahan's 3 daughters being kidnapped by her divorced husband. Now, Ms. Lenahan had a domestic violence restraining order against her estranged husband and had reported her girls missing to the police several times. Despite a restraining order, the cops declined to intervene. Simon Gonsalves then entered the police station and began shooting. He was killed when the cops returned fire. The bodies of the 3 youngsters were later discovered in the back of the truck. So Gonsalves filed a lawsuit against Castle Rock Police Department for failing to safeguard her girls, despite having a restraining order against her ex-husband. So Gonsalves took a case to the United Nations Supreme Court, and just see the what happened in this case was, which concluded in 2005 that she lacked a constitutional right to protection and that the police refusal to to enforce their protective order was not unconstitutional. Gonzalez then filed a complaint with the IACHR, saying that the United States had violated her human rights. The petitioner claimed that the American Declaration requires state parties to take measures to respect and safeguard the full and free exercise of human rights, outlined therein a duty that in some instances involves state action to prevent and respond to private person activity. They also used the due diligence approach to interpret the breadth of the state obligations under the American Declaration in cases of violence against women, which they believe that the state failed to fulfill in this case. The state rejected the parties' arguments regarding the American Declaration, yes, and the applicability of the due diligence principle to the facts of the case, claiming that the American Declaration is a non-binding instrument with the aspirational provisions. B. The American Declaration is devoid of any provision imposing an affirmative duty on states to take action to prevent the commission and crimes by private actors. And C. Even though shall not take action to prevent the commission of crime by private actors. The issuance of a restraining order, according to the Commission, reflects the state's awareness of the possibility that the beneficiaries would be harmed by domestic violence on the part of the restrained party and will require state protection. This acknowledgement is usually the result of a judicial binding that a beneficiary, a woman, her children and other family members will suffer harm. Yes, will suffer harm if the police protection is not provided. It is crucial in establishing whether the state authority should have, not provided. So it's crucial in establishing whether the state authorities should have known that the victims were in danger of domestic abuse if the order's provisions were not followed. The failure of the police to protect Jessica Lenahan and the children who died, according to the Inter-American Commission, was a violation of several elements of American Declaration of Human Rights. Yes, human rights and duties, including the right to life, the right to equality, and the right to judicial protections. Yes. So, Jessica Gonzalez versus United States is the first occasion the Commission has asked to evaluate the nature and scope of the United States' effective responsibility under the American Declaration of Rights and Duties of Man to protect individuals from private acts of violence. The Commission acknowledged and confirmed state agencies' failure to exercise due diligence in providing security and legal assistance to the victims in the case. So yes, in its judgment, the Commission suggested that a member of the federal and state level measures be enacted to safeguard women and children from domestic violence. Domestic abuse has been reframed as a human rights issue in the United States of America as a result of Ms. Gonzalez's Inter-American petition and related activism. So this new arrangement could have ramifications for how our legal and political structure addresses and the public sees violence against women. So some national courts have attempted and promoted the idea of allowing the law enforcement authorities to intervene in domestic abuse case. Now, the Supreme Court of Enforcement Authorities, the Supreme Court of Canada found in favor of police officers who forced their way into the respondent's home after getting a call from his wife and arrested him for abusing her. The arrest was initially ruled illegal because the officer was there on private land without authority. But despite the fact that the police entered the respondent's home without a warrant, the court determined that the intrusion and subsequent arrest were justified based on law enforcement authorities' duty to respond to emergency calls. whenever it may be inferred that 911 caller is or may be in some difficulty, even circumstances when the call is disconnected before the nature of the emergency can be determined, the court ruled. The necessity of the police responsibility to safeguard the justified life justifies and necessitates a forcible entry into a home to check on a 911 callers' health and safety. So, this interference is legal under the common law because it is part of the police obligation to protect the life and property. So, yes, this is very, very important. The plaintiff in Thurman versus State of Torrington sued the city, that is claiming the police department had violated her constitutional right to equal protection under the law. She claimed that the officers ignored her estranged husband's assault on her and refused to follow his probation restrictions. The city and 24 of its officers were found to have violated the Thurman's 14th Amendment right to equal protection. So Thurman reported her husband's threats to the police several times. Despite guarantees from the police, they were unable to apprehend him. Her spouse eventually stabbed her, disfiguring her and partially paralyzing her. A police officer may, yes, not automatically decline to initiate an arrest just because the assailant and his victim was married to one another. The court concluded Tracy Thurman was paid 2.3 million pounds in the first landmark case in 1984 in Torrington, Connecticut, and several police stations revised their policy on responding to domestic abuse as the result of the case following Mrs. Macia's death at the hands of her violent husband. Her family filed a lawsuit alleging that her constitutional rights had been violated in estate of Maria Teresa Macias versus Mark. So, after the court determined the murder was not a constitutional deprivation, the claim was dismissed. The Court of Appeals overturned the decision, arguing that the constitutional deprivation, not murder, was the breach of equal protection. So, according to the court, in this case, the alleged constitutional violation was Mrs. Macia's refusal of equal protection, police protection. The district court, in concluding that Mrs. Macia's murder, was